Um, Boy, does the news cooperate with us, right? In the sense, if we're going to study the nature and fragility of democratic constitutionalism, it couldn't be more propitious in terms of, right, this week being a week where we began to see how fragile even what I think of as one of the true pillars of our experiment with democratic constitutionalism, the First Amendment is, right? And so today we will continue this conversation, coming up to speed for a few minutes with what's been happening in the last week since we got together to talk, but then continuing to drill down and really beginning, I think, to open up a more general historical consideration as well as a normative one. How should we conceive of democratic constitutionalism, both in terms of the long-standing American experiment with this and its successes and its limits, and then also in a more principled way, what is it we should want out of a democratic constitution and the institutions that support it in the 21st century? So, with that framing, let me jump right into the news of the week. And I think the big news here is, right, that in the aftermath of the killing, the tragic assassination of Charlie Kirk 2 weeks ago, this has become a flashpoint, a rallying cry that in many ways what people on the left may have been doing 10 years ago, which is trying to police social media for what they regarded as hate speech, has migrated now very much to the right, with, I think, really important, profound differences. The effort on the left was decentralized. It was peer to peer, right? It was individuals pointing out that there were user agreements to various social media platforms that prevented people from saying certain things that were regarded as hateful, as insulting and targeting particular groups for discrimination, as forms of disinformation. And they tried to use the terms of agreement of the platform, right, the terms of use, to quote, cancel, literally cancel the agreement and then the capacity of the person in question to post on that platform. Most notoriously, most visibly, Donald Trump was canceled on Twitter and Facebook. That means his ability to use those platforms to share information and reach his followers was suspended in the aftermath of the January 6th invasion of the Capitol and the sense that Donald Trump had used his social media presence to try to incite that lawless and dangerous action, right? And so that's just an example, right? And over the last couple of weeks since the Charlie Kirk assassination, there has been a parallel kind of mirror image effort on the right to look for people who are critical of Charlie Kirk, to treat that in the aftermath of his assassination as a litmus test for whether or not those people should be canceled, should be targeted, and the campaign has targeted them not only for removal from social media platforms, but has also encouraged people to be reported to their employers and fired from their jobs. And I want to point out, right, that some of the criticism of Charlie Kirk has been in, minimally speaking, bad taste, right? In the aftermath of a grievous assault on the norms of civility, right? Nobody should, I think, come close to something that seems to endorse or condone or excuse political violence. And if you do, then you should be held to account. But I do believe that the question of how you should be held to account and how much latitude there is for friction, for contestation, for heated exchanges in an open, civil, public sphere of a democratic society is a very difficult question to answer. And it's one that requires that we err on the side of over inclusion. And then we add, by the way, Charlie Kirk, to say it plainly, said many things that were highly provocative and many people found to be quite hateful and offensive. And when you point out in the aftermath of his death that he said those things in order to try to create a balanced perspective on who this man was and what his contribution to the conservative movement, to the MAGA movement, to overall discourse was, then I think you are not excusing political violence. You are trying to introduce a balance into the processing of a tragic death and a potentially dangerous and spiraling moment in our society. And so, if you will, to put it plainly, I think the attack on the people who posted about Charlie Kirk was overly broad, as constitutional lawyers like to say. It wasn't just focused on people who tried to excuse or even justify the violence. It was focused on anybody who criticized a man who said a lot of things that, frankly, in other circumstances, it would be totally legitimate and expected to be criticized, right? And then we add that unlike the right mirror image of this campaign, the effort on the left and the past to remove people who are hateful and violating the user terms of social media platforms, this very quickly was taken up by the Trump administration. And it was taken up in ways that included using levers of highly centralized and extraordinary power against individuals who were criticizing Charlie Kirk. And I think that is the context in which we should then think about the suspension of Jimmy Kimmel's contract, right? And his removal from ABC and his late night perch in the context, by the way, of something similar, if not identical, having happened to Stephen Colbert a couple months earlier. But the particular details here in which the chair of the Federal Communications Commission, the FCC, right, says, echoing a line from a mob movie, right? There's an easy way and a hard way for this to go down. And the easy way is for ABC to cave and fire him. The hard way is for the FCC to go after its syndicates, to try to make life hard for this network and its corporate ownership and the channels that carry this programming, and to do so in ways that may interfere with their proposed mergers, their business model, their right to use the public airwaves. And at this point, I think, right, it becomes clear that the idea that there is an ongoing pattern. I don't know if the Trump administration had a plan prepared in advance to execute in the event of some extreme provocation. Here's what we do, or if this is more spontaneous. But in either way, this is beginning to look like there is now a consolidation of the autocratic control, the use of government power to diminish our capacity for criticism of this president, for free speech, for dissent, for revealing relevant information about what this administration is doing. And by the way, I think it is not an accident, as I think others have pointed out quite forcefully, that the targets are very often people who use comedy to ridicule the President of the United States, because I think it's clear, right? Donald Trump has a small, brittle ego. He can maybe put up with being directly argued against, but someone who makes fun of him really, right, provokes him. And by the way, I'm not saying that Brendan Carr is directly on the line with Donald Trump and Donald Trump is saying, get Jimmy Kimmel off the air. The principle we've talked about before, that the way presidential administrations, which are these vast Baroque institutions, work is by people within the administration internalizing what they think the orientation, the disposition, the desires, the modus operandi of the president is. And it is quite clear that the people in the administration, the people in the high levels within the Trump administration have internalized that Donald Trump is a bully, that Donald Trump does not like to be ridiculed, that Donald Trump does not hesitate to use political power, whatever power he has, to intimidate, chill, or silence those with whom he disagrees. And that we are in an ongoing and I think increasingly cascading moment of danger for freedom, for liberty in the United States is becoming increasingly clear, right? And so in addition to that, right, in addition to the Supreme Court, as we discussed last week, allowing race to be used, and I do think one of the things as we get into the history we can start talking about is the parallel between the aftermath of the Civil War and Reconstruction, the period that's often called in American history the Redemption, and the role that the Supreme Court in particular played in dismantling Reconstruction, in undermining the policy that was put in place by radical Republicans to try to undo some of the aftermath of slavery, some of the efforts to reconstruct, right, the South as a society that would be genuinely democratic and not a place of racial tyranny, and the way in which the court, right, undermined that effort, legalized the effort to restore racial tyranny, and did so in a very uneven or tendentious way, disallowing the law that pursued racial equality, permitting and amplifying the laws that undermined it, a series of decisions that notoriously ends with Plessy v. Ferguson. Are we in a similar period with the use of race, this time so far primarily targeting Latino and Latino Americans? And by the way, we also have an emergency appeal on the shadow docket from the Trump administration to do what he couldn't accomplish last week in the district or the circuit courts, to have Lisa Cook removed from the Federal Reserve once and for all. And by the way, if he is able to do that, he will have consolidated complete control over the most powerful economic institution in our society, the Federal Reserve, and the idea that there will be fewer and fewer institutions capable of resisting the consolidation of power, I think will be increasingly clear. So that's what's in the news right now, right? And I'm going quickly through this because I want to move past. We've spent a lot of time in the last couple of weeks primarily focused on the immediate, right, context for discussing the Supreme Court, the Constitution, and whether or not they're still working in the 21st century. Let me say one more thing as I begin to transition into more historical and more principled themes. And that is that I assume that ultimately we will have free and fair elections in this country. When I say I assume, I guess I mean I hope. I guess I'm indicating that I believe that although we are seeing the erosion of the institutions that make us a free society, it is still the case that it is deeply ingrained in our culture that we decide our elections. We decide, I'm sorry, our leaders, the people who get to exercise power over us via free and fair elections. And I will point out to you, right, that Donald Trump remains quite unpopular. I'm noticing that he's not actually growing more unpopular, which concerns me, but it may just be he's hit his floor, that 40% of Americans want what he's doing and 50% of Americans don't, and the other 10 are kind of in the middle, right, or not paying attention. But I would also note, right, that we pay attention to barometers of the national mood. Do you feel that this country is moving in the right direction? And in that regard, we're beginning to see polling indicating that we are at a very low point. As a matter of fact, one recent survey suggests that using that question, the national mood is as bad or almost as bad as it was following the attacks of September 11th, 2001, that it hasn't been this bad since then, right? And so there's some indication that although we are in dangerous conditions right now. I'm calling it a perfect storm for exposing the fragility of of American constitutional democracy in the 21st century. It is also the case, I think, that we may emerge from this, that the 2026 elections may restore the Democrats to power in at least one and hopefully maybe two houses of Congress, that right now the Democrats are beginning to find their spine, beginning to use what power they have to exercise some leverage to resist Donald Trump. I'm speaking specifically of the failure of the continuing resolution and the likely shutdown of federal government in the United States and the effort to use that specifically to restore funding for Medicaid and Obamacare, but I think more generally as a way of expressing, right, and calling attention to the problems with the abuse of power and the attack of freedom in the Trump administration. And so let's envision a scenario for a moment in which in 2028 there is a free and open election, right? We're not in competitive authoritarianism, which I want to be as clear as possible. There's no guarantee that we're not. And if I think Trump fully succeeds, we may very well be not able to have a free and fair election. It's hard to have one if the press is muzzled and muted, if the opposition is defunded and disorganized because you've used the IRS and the Treasury Department and your federal funding for housing agency to dig up dirt and do your best to intimidate the opposition. But let's assume, right, that those efforts ultimately do not fully succeed and that we have an election and that the verdict of the American people is that this is enough and it has to stop. And the result is that the Democrats are returned to power. What do we want the Democratic Party to do? And here I think one possible silver lining in the very dark clouds looming over American democracy right now is the idea that it might help us to identify the deep structural weaknesses in our 18th century Constitution and begin to rise to the challenge of repairing them. And so that's the direction I want us to pivot in. I want to be as clear as possible. I get asked by you and others on a quite regular basis, what can we do? I don't think there is a silver bullet. I don't think there's one thing we can do to, right, be able to navigate these choppy waters successfully. It's going to take the actions of many, many people on many, many fronts. It's going to take courage. It's going to take organization. It's going to take perseverance, and it's going to take vigilance. But assuming we do get through it, we do actually come out the other side with some capacity to pursue reform. What kinds of reforms should we be pursuing? How should we orient ourselves in the aftermath of the second 4 years, the more dangerous 4 years of a Trump presidency? And there, I think that the Democrats, or right, the opposition currently, may have an opportunity to identify reform. And that is where I want to go to
Hmm.
try to begin to outline that with you today. So, why is this a perfect storm, exposing the frailty of the American Constitution? And why is the Supreme Court, as the last bastion to protect it, not seeming to be right, doing the job that we needed to do, inspiring any confidence in it? And I do think a large part of this has to do with the character of the Supreme Court, the justices on the Supreme Court, the 6 member, very conservative supermajority, in many respects seems to actually agree with the agenda that Donald Trump is pursuing, and seems either to have an interpretation of the Constitution that permits him to consolidate and use the executive office of the presidency as an agency of autocracy, or else, if it doesn't agree with that as constitutionally permissible, they seem to have decided, well, we can put up with a little constitutional damage in order to get this policy agenda accomplished. We've talked a little bit about this. I'm not going to go into further detail, but the idea that we don't really have a clear sense, and it may be that, right, Alito and Thomas are in one place, and Roberts and Amy Coney Barrett are in another place, but be it as it may, I think it's worthwhile characterizing the majority of the Supreme Court in general as maximalist, supremacist, regressive, destabilizing, and anti-democratic. And I hope this is clear. They're using their power. They're using their power as fast as they can. And they are indifferent to the question of whether or not the way they interpret the Constitution agrees with, or in fact departs from, the way in which most Americans regard the Constitution. Their interpretation of the Constitution wants to take the Constitution back 70, 80, 100 years. And to do that, they are destabilizing not only precedent, overturning or disregarding what seems to be the guiding legal standards in many of the cases that come to them, but also in many ways destabilizing the role that the rule of law plays in our society, in giving us some sense of what our rights are, what we can expect of our government. I don't think any of us expected that immigration and customs enforcement would be in the interior of the country, sweeping through car washes, workplaces, and public parks, looking for people on the basis of race and accent, and then detaining them. That does not feel like the America most of us have lived in for the last 50 years, and yet that is what the court is permitting. Finally, that it is anti-democratic in a twofold sense, right? It does not view its own role as in any way an institution that expresses the sovereignty of the people of the United States. And in its decisions, going back to Citizens United, Bush v. Gore, its string of anti union decisions, its licensing of extreme partisan gerrymandering, the Supreme Court has thwarted the desire of the American people to use their votes to equalize their power over the fate and direction of our society. And this tendency in the Roberts Court has been accelerated on the one hand by the three new appointments that Donald Trump had in his first term, and on the other hand by what Trump is doing with presidential power in his second term. And so the idea that the autocratic use of executive power, and note, this is straight out of the gates, the first day he is in office, on stage, signing executive orders. I should note, and we'll get there in a minute, but the idea that Bezos and Musk were on stage with him, along with Zuckerberg, that there was a clear indication that this was going to be a different Trump presidency, that the oligarchs, that the technocrats were aligning with Donald Trump in 2025, saw advantage and potential opportunity in his presidency, and they were therefore going to not criticize, not check, not undermine, but in fact perhaps amplify his power, So this is putting, the president and the executive on a collision course with what had been the constitutional consensus up until that point. And it's stunning to see how quickly that consensus is crumbling, how fragile it in fact is. And that is not because, the lower courts haven't risen to the challenge. They have, and they're continuing to do so. And by the way, as I've said to you in the recent past, they are increasingly pushing back against the Supreme Court. There's a good article by Michael Dorff of Cornell Law School who basically argues this is what lower courts should be doing. They should only be subordinate to the Supreme Court when the Supreme Court is actually behaving like a court. And in 2025, the Supreme Court isn't. And so the lower courts are taking over from the Supreme Court the responsibility of maintaining our Constitution and the kind of democracy that it enables. But the Supreme Court is on the attack. And they're just signs of deep fractures within the judiciary. The idea that the Supreme Court, I think we can see increasing signs that this conservative supermajority is going to continue to enable and amplify Trump's policies of aggrandizing executive power, that it seems to have convinced itself that as long as Donald Trump is president, the unitary executive theory is the right way to interpret Article 2, Section 1, despite the copious textual and precedential evidence that this is just a silly, fig leaf of a reading. And that this means that the court will increasingly be at odds with not only the lower courts, but also a stable majority of Americans. I then want to add, coming back to the oligarchs on stage on the inauguration of Donald Trump, that this occurs in a period of highly concentrated corporate power. So this is part of what's happening with Skydance taking over a CBS and Disney taking over ABC, and these holding companies or the hyper wealthy people who control them being much more interested in their power and their wealth than the principle of the freedom of speech, So the fact that you have really well-regarded news organizations settling suits that would be laughed out of court, in the way that the New York Times sued Donald Trump, suing the New York Times for $15 billion, was dismissed outright. You don't even need to go to court to argue this, The case makes so little sense, and yet they settle rather than fight. because their interests lead them to want to have the administration on their side. And they know if they play ball, it will grease the wheel for them accomplishing what they want to accomplish. We combine that with an oligarchic structure of wealth, right? 0.01% of the population contributing, it looks like, more than 60% of the money that was spent in the 2024 presidential campaign. We combine that, right, with a media system that is fracturing and spreading disinformation and deep disorganization in civil society, right? The idea that we are privatized, we aren't going out in public as much as we used to, that our unions have shrunk dramatically in terms of their membership, that our civil society associations have withered on the vine. And the idea that there might be a fourth estate, a press that would stand up for itself and hold the government to account, fight to defend the principle of freedom of the press, or other countervailing powers, right? Organizations in civil society capable of standing up against the government and holding it to account when it abuses power. Again, I think this is not there, right? And this raises a whole bunch of questions, some of them judicial, some of them political, some of them democratic and constitutional. And I want to focus on the democratic and constitutional questions today and in the week or two to come. And so I will just jump in, right? And I want to start with the current majority on the Supreme Court and start with a basic contrast, right? This is the Warren Court in 1953, right? They're on the cusp of what many consider to be the proudest accomplishment of the Supreme Court in the middle of the 20th century. They're on the cusp of deciding the Brown v. Board decision. Please note there are 8 Democrats and 1 Republican on this court, but the Republican Earl Warren is actually the one who assembles the majority in Brown v. Board. And please note, right, that the 8 Democrats include Dixiecrats, right? They include people who are, I'm sure, in their political and personal lives, unsympathetic to the idea of dismantling Jim Crow. But these men, when they put on their robes, shed their political partisan loyalties and thought about the issue from the perspective of the constitutional values at stake. And I think it's worthwhile pointing out, right? Earl Warren was on the Supreme Court, headed the Supreme Court for the better part of 2 decades. And over that time, the court transformed. More Republicans joined the courts, more Democrats, the FDR, right, appointees, as well as, right, his successors' appointees dropped off the court. Eisenhower was able to appoint more people. And by the time, right, that Warren is leaving, actually, right, we're in the beginning of the Nixon presidency. And what you have here, right, is now a 7-2 Republican majority and continuity with the 8-1 Democratic majority. Party did not matter nearly so much in the second half of the 20th century as it does in the 21st century, right? And so I want to develop this contrast by noting how the majority on the Supreme Court was made. And here I recommend, and we've talked together before about Stephen Tellis's book, The Rise of the Conservative Legal Movement, The Battle for Control of the Law. And this is a book that's primarily focused on the Federalist Society, but also on a broader campaign, a campaign that included, right, a campaign to get the right kind of Republican elected to the Senate, the right kind of Republican elected to the presidency, to make certain judicial views the litmus test of the willingness to support those people, but also, right, an effort to get conservative law professors appointed in the most prestigious law schools in the United States so that the people graduating from those law schools could be potentially steeped in a more conservative understanding of the Constitution, right? The reason this was such a protracted and expensive campaign is that they were patient in building the infrastructure. They recognized that if you want to remake the Supreme Court, you need to have credible conservative jurists coming out of Harvard and Yale and Stanford and Berkeley, the top law schools in the country. I guess I should add Chicago to the list. And right, you need therefore to actually fund viable conservative curricula in those law schools. And so this is a long, expensive, patient effort. And it's not just the six justices on the court that it produces an entirely distinct legal culture that constitutes nearly half of the federal bench in 2025. And by the way, we should remember that Donald Trump will no doubt appoint a large number of federal judges over the next 3+ years. And so this movement will continue to transform American law. And I want to just point out that as opposed to, right, the court on the right, the Warren Court, which reflects what I'm calling the complex organic evolution of jurists and citizens' constitutional understandings. And that is mediated by both court decisions and electoral outcomes, right? So FDR is able to remake the court because he wins the presidency again and again. But it's not just that he remakes the court through appointments, it's also that the people that he's appointing come to have a changed view of the Constitution in light of his political success and what it says about what the people of the United States want from how we understand our Constitution, right? And so that is a model of the evolution of the court, of the judiciary, that accounts for a attenuated but real democratic sovereignty and accountability. And as opposed to that, right, I want to suggest that this court, right, results from the expenditures. And by the way, the people who study this think that TELUS is being very conservative. People think that it may be 2 to 4 times that much money that was spent. That is to say, $1 billion to $2 billion. And to be as clear as possible, this was all focused on transforming the judiciary, right? And so capturing the court by partisan and vested interests that basically have an agenda that they want the court to accomplish, and that agenda, right, is not one that reflects the right organic evolution of the understanding of the Constitution. It's one that reflects the narrow interest of the hyper wealthy people who have funded this campaign. That's a corrupt evolution of the court and of the jurisprudence that the court conducts and is responsible for. So the result of this campaign, I'll say a little bit more about the campaign in a minute, is the first originalist majority on the Supreme Court. And I hope that terminology is clear, but the idea that the right way to read the Constitution is by ascertaining, well, what the people who drafted it intended to do with the Constitution. The right way to read the amendments, what those who drafted the amendments intended to do in drafting the amendments. Or maybe it's broader. Maybe it's what the people who ratified the Constitution and the amendments understood they were doing. Or maybe it's still a little bit broader, how the language used in the document reflects what those words meant at that time. But in one of those three regards, right, the Constitution needs to be grounded in the 18th and the 19th and the early 20th century and not a living, evolving, organic document that continues to reflect the evolving sovereignty of the people of the United States. And that this is then, right, a really profound development. And I will say this now and then develop it as we get further on. I do not believe that originalism is actually a defensible or coherent way of reading the Constitution. In ways that I'll get into, I think it's a self-undermining idea. It is incoherent, right? But having said that, it is now the position of the majority of the court, and it is a very convenient ideological position. It's a position that allows them to do a lot of what they're trying to do and allows them to say this is not mere partisanship. This is not merely the fact that we have sympathy, politically speaking, with this agenda. This is what our principled understanding of the Constitution requires of us. So, in addition to that, right, this means that the current court is growing more and more distant from what most Americans understand and want their Constitution to mean. And it amplifies the power of conservative vested interests and a minority of the electorate. I want to be as clear as possible, right? We'll talk about this right now. The origins of this are in the Powell memo written by Lewis F. Powell Jr. in 1971. Lewis Powell, of course, goes on to be a member of the Supreme Court. At the time, he is the chief counsel for the American Chamber of Commerce, right? A conservative business agency. And this memo urges the American business community to take aggressive long-term political and legal action to transform the judiciary, and in particular to counter what he saw as an assault of the judiciary and the administrative state on the free enterprise system. And so I want to be as clear as possible, right? That may get you 500 million or $2 billion for this campaign because there are a lot of rich people who are going to be very interested in having their businesses less regulated, being able to do what they want to do without the EPA breathing down their neck, without having to pay high corporate earning taxes, etc. But that's probably not going to win many elections, right? And you don't get to reconstitute the federal judiciary without winning the presidency and controlling the Senate. And so this led to the formation of a coalition. And it's a coalition that joined anti-regulatory ideas to an anti-abortion campaign, right? And where I think it's appropriate to view the way in which abortion mobilized the evangelical Christians to support for quite a while this drift in the Republican Party as a way of expressing a desire to live in a more traditional, traditionally gendered, but also traditionally religious, a more stable society. And then also to express antagonism with the rights revolution, especially with civil rights. And here, right, the idea that beginning with Richard Nixon, we saw the Republican parties develop, the Republican Party and its presidential candidates develop and then follow the so-called Southern strategy to bring on board the former Dixiecrats who felt like the Democratic Party turned against them, like they were losing their privilege, their standing, their authority in the once solidly Democratic South, and the Republican Party was going to stand up for them, right? And so that coalition forms and begins to do the work of reconstituting the federal bench. This is a long patient campaign, and it's waged on multiple fronts in higher education, especially law schools, but even at the undergraduate level, in electoral politics, obviously, but also in think tanks. I think it's worthwhile noting, right? This is in many ways the origin of the Heritage Foundation, the authors of Project 2025, and eventually it gives credibility to this reading of the Constitution. And now I just want to share with you, I think, a little bit about where we can expect the Roberts Court to go in light of this history. So I have on the board here a survey that one of the Federalist Society publications, a publication called Law and Liberty, did recently. And they surveyed a large number of Federalist Society law professors, conservative law professors who belong to their organization, and asked the question, what were the 20 worst decisions in the history of the Supreme Court? Well, they got number one right from my point of view, Dred v. Scott, right? And the decision that permitted the spread of slavery and ultimately was strongly contributory to the Civil War, right? That's about as bad as a Supreme Court decision gets. But closely trailing at number two, right? You can see they ranked this by points, right? That Roe v. Wade was very close to Dred Scott in their estimation of the worst decision in the history of the United States, and the idea that Roe v. Wade is much worse as far as these conservative scholars are concerned than Plessy v. Ferguson, right? The decision that dismantles Reconstruction, that allows redemption, allows Jim Crow's segregation and disenfranchisement, not as bad as Roe v. Wade. And then please note, right, the remaining, right, decisions above Korematsu, right, the decision we talked about last week that allowed the rounding up and internment of Japanese American citizens for no good reason other than their race, no credible suspicion of actual disloyalty. These decisions, right? Planned Parenthood, another abortion decision, Obergefell, right? The decision that allows gay marriage, right? Griswold v. Connecticut, the decision that allows women a legal right to contraception. I think we're beginning to get the picture here, right? The decisions that enabled women to control their own bodies and sexuality are worse than the decisions that countered racial hierarchy. And the idea that this is probably where this court is going, right? By the way, Lawrence v. Texas, rounding out the top 10, in which, right, the Supreme Court says, actually, the police in Texas can't invade your home to police whether or not you're having gay sex in your home. That's a terrible decision as far as conservative justices who the likes of Alito and Gorsuch and Kavanaugh and Thomas move in the self-same circles with, emerge out of this movement. I think this should be a sobering indication of where this court is going. And so I will conclude here today, but I just want to note, right, we've spoken extensively in the past about Project 2025, and the head of the project described it as a blueprint for, quote, institutionalized Trumpism, that there should be a movement that transcends Trump, that is nevertheless rooted in Trump's approach to the presidency, and the idea that this is, in other words, a blueprint for an autocratic takeover of the federal government. And that this, right, project, there's a tracker online. I'm only giving you the very broad overview, right? But that it goes line by line through this 900-page publication and asks, what are the goals and how far are we in getting them accomplished, right? And right now, 8 months into the Trump second term, we are 47% of the way into executing the detailed autocratic playbook that Project 2025 outlined. But what I want to really talk about today is the way in which the Supreme Court seems to be completely on board with Donald Trump implementing Project 2025, but also with the idea that this should be institutionalized, that this should not be something that is a product of the election of 2024 and can be easily undone by the election of 2028 and subsequent elections. How do you get this more deeply ingrained into American law and society? And that takes me back to the Powell memo to the Federalist Society and to the dismantling of Reconstruction in the 19th century and its replacement with redemption. And the idea that if you try to do this by law alone, well, ordinary law can be changed or revoked by ordinary majorities. If the Democrats win power, they can undo a fair bit of what Donald Trump has done in the previous 4 years. If they gain power in 2026, well, then the Trump revolution may be halted in its tracks. But if you change the Constitution, constitutional interpretation, constitutional law, if you capture the court, all you have to do is count to five. And that court, by the way, seems increasingly unabashed about operating in a highly uneven way, right? Very sympathetic to Donald Trump's use of executive power, very hostile to Joe Biden's. What makes us think that they won't be equally hostile if there's another Democrat in the presidency? And then please note, right, this is the book that you can order next month from the Heritage Foundation, the Heritage Guide to the Constitution. This is actually the third edition of this book, right? Please note, Samuel Alito writes the preface. And if you really want to see where this court is likely to take our Constitution, I think you're going to recognize very quickly that there's not just a presidential, there is a judicial Project 2025, and it is being executed quickly and radically by the current Supreme Court in concert with the current president. And so that's the basis for my saying we have to get our foundations in place for understanding what we want out of a democratic constitution in 2025 and 2028. That is where we will go in the next class together. We'll look at this in a principled way. We'll look at it in a historical way as well. I realize I went fast and hard today. I have a few minutes for your questions. Anybody want to start us out? Flossie, go ahead, but you do have to unmute yourself. Anybody close by to Flossie or with her to help her do that?
Can you hear me now?
Yes, I can. You got it. Perfect.
I haven't trusted Justice Roberts since the time he was being considered a possible candidate for the Supreme Court. He was so cagey about being able to answer simple questions directly that one of the senators, just in desperation, asked him if he had a favorite movie. That seemed human, not to Justice Roberts. His favorite movie, and it's possibly a lie, was North by Northwest with Cary Grant
Yes.
being chased by all kinds of bandits who are no doubt Russian or liberals. It was so dis how can so contemptuous of the Senate, of the American public. We're nothing to him. We're dirt. I have never trusted that man. If he is an aristocrat, he will cut his own throat because Trump is basically Obama, and Trump will get after him in his own way. I think the fun, pardon me, is just beginning. Thank
Yeah.
you.
And I'll say this very quickly. I didn't remember the incident in question. I do like Hitchcock. I do like that movie, the famous scene with the plane. But having said that, um, two things. The first is that it has become increasingly common for the candidates to the Supreme Court to give completely evasive and disingenuous answers to the Senate. And the result is that the process of confirming them has become a completely partisan exercise, right? And that does a disservice to democracy. It's one of the places where it seems to me we need to be asking then, is it still working for democratic constitutionalism for the Supreme Court to have as much power as it has? And I'll preview. I'm going to suggest to you in coming weeks it's not, and therefore we need to reconsider not just who's on the Supreme Court, but the very constitution of the Supreme Court, if you will. But then let me say a little bit more about John Roberts for a moment here. And I think that there are some of us who, in our more optimistic moments, had some hope that Roberts was a quote institutionalist, that he was somebody who cared enough about the reputation of the court that he was going to, even if he wanted to change it, do so gradually, do so incrementally, and maybe that he would exercise a moderating influence over his colleagues to try to convince them, well, we can do what we want to do, but let's not do it all at once. Let's not be maximalists and supremacists in the vocabulary that I've used. And that John Roberts is nowhere in sight, right? And please note, right, as we've discussed, this is the Supreme Court, the Roberts Court. It's coming up on 20 years now, right? That handed the presidency to George W. Bush, that told us to stop counting the ballots in Florida. This is the Roberts that dismantled campaign finance regulation in the Citizens United decision. This is the John Roberts who oversaw the dismembering of the Voting Rights Act, who has allowed rampant partisan gerrymandering, who has targeted again and again our capacity to organize unions. And so in all of these respects, yes, I think Robert's true colors show in that lineage of decisions, all of which I think I can describe as anti-democratic with a small d. They have dismantled the capacity of the people to use their numbers to exercise control over our Constitution and society. And by the way, it looks like he is just getting warmed up. And he has a president he likes and wants to enable and empower and work with. Yeah. Thank you, Flossie, especially for calling our attention back to the confirmation hearing. Mike, go ahead. You have to unmute.
As a lawyer, I compliment you. Everything you've said is prescient and accurate, particularly how you characterize Roberts. The man is a snake in the grass. You could tell with his big first decision, which was Citizens United.
Yeah.
He's a terrible, terrible person.
Well, I do appreciate the vote of confidence. As you know, I am not a lawyer, and I am not steeped in constitutional jurisprudence the way the books that I'm reading are. But I'm doing my best. I'm trying to come up to speed. I think this is urgent enough that we need to be thinking about it. Thank you, Mike. I do appreciate it. All right, so I got to make it to Manhattan in the next 45 minutes. It's great being with all of you. I'm glad we were able to work out the schedule so that we could do this. I look forward to seeing you at the regular time next week. Be well, everybody. See you soon.
Thank
Thank
you.
you. Take care, guys. Bye bye.
Thank you, David.
Pleasure as always. Thank you. Bye bye.